So shall we resume? I can barely hear one yes.
Yes, ma'am, we can.
Yes, ma'am.
We are all back?
Yes, ma'am.
Yeah, I think more or less. Okay. So I think we should have a very quick recap of what we did in the last session, because this time I'm recording the proceedings. So we can have a look at this. Okay, let me share the screen so that we can have this also. Okay, where is this share screen? So what we wanted to have a look at was Richa Mishra's the basic decision of the court on the primary issues. One issue was about appointment, whether it was rightly done under Rule 2000, and the court has said yes, it is rightly done. And then on the second question, that whether even when the appointment was rightly done in 2000 rules, whether she was still entitled to a relaxation of 10 years of age by reference to the Rule 2003 and others. And we did say in our last conversation that it is paras 26 to 30 of the judgment, which contain various reasoning. The first one was on 15.3, and we were talking about that when the judge has given the reasoning that 15.3 is inclusive of providing for economic empowerment as an essential action to be taken for ensuring women's equality. What is it that the court was talking about? Was it talking about paternalism? Was it about patriarchy? Was it talking about paternalism, equality, sameness, and difference? And we do know that the moment we talk about Article 15.3 as referring to women as weaker sections, we are into paternalism. And therefore, if we want to change that conversation, say it is not paternalism, 15.3, whether Article 15.3 is about paternalism of the law towards protecting children, women and children, uplifting them, or is it also recognizing the difference, whether 15.3 is coming only because women are weak or because women are different. If we say women are different, then for our present conversation purposes of this case, how we justify the relaxation of 10 years to women candidates? That's the point where we broke and we said, okay, read the other paras also, and then come back and explain to me what you think can be the alternate reasoning to say that this is not only about paternalism, but it is about recognizing the difference. So what do anyone who has a say in the matter? What kind of reasoning can we give for saying, reaching the same conclusion? We are not saying that come to a different conclusion. For coming to the same conclusion, we need to find out. Now I can't get my PowerPoint in a, okay, let me try again. Perhaps I'll restart. So tell me, what do you think?
Ma'am, if I may.
Yeah.
So in Article 15.3, one of my peers, she said that it's a paternalist. What I figured out that the court approached it through a different vantage point, which is basically a social justice. And if we apply the concept of equity, the court and even our constitution, which is essentially a feminist document, has accepted that in Article 15.3, women and children, they have been a subgroup which has been always been not given opportunities, kept away from the resources. Therefore, in order to bring social justice, which is enshrined in our preamble, it is essential for subgroups who have never had equality or equal opportunities to give them an affirmative support in order to bring them together in the society. Even if we read the para 30, there are several places where the court has very well mentioned that the goal for securing all citizens is justice, liberty, equality, and fraternity, and it has highlighted the achieving the purpose to be an achieving social justice.
Mm-hmm.
So if we see this as the code or the constitution providing support to those subgroups which have always been neglected in the social order of our country, so in that way we can see that article 15.3 necessarily does not only be paternalistic but also it accepts that these are the subgroup which needs more affirmative support because they have always been neglected in the history of the society.
Okay, who was speaking? Who was this?
Ma'am Rahul.
Rahul. Rahul, when you take this position, again, are we not talking about paternalism again? How would you distinguish paternalism from the biological difference? What I'm actually hinting at is that can we make a reasoning saying that because biologically are different, they are required to produce children by society and by body, and therefore they are bound to lose certain years. It's nothing to do with they being weaker or not weaker. It's a biological function which women's produce, which discharge, and therefore giving them is nothing a special favor. It is not because they are weak, but because they need it. They need it because that is the way they are made. That's the way they are as a human being. So we take that approach, then we're not talking paternalism, we're not talking patriarchy, because the moment we say because they are weaker, because they have these family responsibilities, we are getting into the argument on patriarchy, that they have been doing so, they will continue to do so, and therefore we will facilitate. So we are not changing anything for them. We are not saying that because they have a biological function to be discharged, and therefore they need to have extra years in order to cope up with whatever is lacking because of the obligation they have, because of the biological body they have as a human being. So that argument is not coming from patriarchy saying, oh, because women are weaker, therefore they should be given. It is not coming for paternalism that because they are weaker, we will provide the protection. It is coming from the difference. The consequence will still be the same. The reasoning must still be the same. Saying that yes, because 2003 legislation, and it can always be said. I think I like the judge's reasoning when the judge says that it was an accidental omission, and therefore,
Ma'am, I have a point.
yeah.
Ma'am, I agree with you on this that yes, because of the childbearing, yes. But if you look at the CAD of 15.3, and also it can also be seen through this way that even it was mentioned in CAD when 15.3 was discussed that in our social structure women were always men would go to schools, men would get education, but women, very less number of women got
Mhm,
education. And even if we compare at that point of time, if we compare the education levels, school going level, college going levels of women and men, it could be seen that because of the societal structures and the narratives present in the society, women
mhm,
were not allowed or barred from going to schools and colleges. So it
mhm,
itself, the societal structure itself prevented them. It was like running in a race with a 50 kg burden on them.
mhm.
So the societal narrative itself prevented them to be to go to the colleges or school or to be eligible for posts or government jobs in this context. Therefore, the 10 years relaxation may can also be looked through the vantage point that because that subgroup women lived in a societal structure where they were not allowed or not encouraged to go for education at schools, colleges. Therefore the affirmative support is needed in this context.
I have no disagreement with what you're saying. You're saying whatever you're saying is correct. The Constituent Assembly also at that point of time is all talking paternalism only. The point I'm trying to make that is it time to start moving away from paternalistic discourse to rights discourse to a different discourse? Because correction has to be made. But correction has to be made because in this society she has been she has been neglected, because she has not been participating or allowed to participate in the public sphere. She doesn't have equal opportunities for employment. All that is a given. But the reason for changing that, is it because of the given or because of a different construction of women itself? So the different construction of women is that they have a biological obligation, or not an obligation, but a biological function. So for me to say, because the Constituent Assembly talked about paternalism, therefore, after so many decades of independence, we should still refer to what they thought is correct or not. Because when we look at the language of the statute, we do not go behind the statute and do not start looking at what the objectives of the framers were. We look at what the law says today. The law says only today special provisions can be made for women and children. So given that, so the one popular discourse which is also found in the judgment, and which also you are saying, reiterating, is that because women and children, and in this case we're only concerned with women, because women are weaker, because they have been ousted from the public spheres, because employment is essential for their equality, therefore we must ensure that they get it. It's, for me, it's a paternalism discourse, recognizing patriarchal division of labor. So that's one way to reach this conclusion where the judge has reached. The judge has precisely taken the same line of argument. I'm asking us to explore, is it possible to think about an alternative discourse to say women are different and therefore they require different service conditions? They are different in this particular case because of their biological functions of childbearing and rearing, because they have to spend some time doing that, and therefore as a class they should have a higher cutoff in whatever ages are. In this case it is only for the employment purposes. I've been saying this, why should it not apply for retirement purposes, for all other purposes? Once you say, because whether our discourse has to be limited to only this case, that what is it that the judge is talking about and what this is that the judge has provided for this class of officers. So it's such a certainly progressive judgment, no doubt about that, and it's a desirable line of reasoning in terms of comparing the previous rules and the 1997 rules, the 2000 rules, 2003 rules, and 2005 rules. And it's a very, very innovative manner in which the judge has said, I will not go by literal interpretation, I will go by purposive interpretation. And looking at all the series of laws applicable on this case, there is no rationale to say why in 2000 the state would not want to give the same relaxation to women which it has been giving in the past and has also ensured in the future. So that's a perfectly sound logical reasoning, and I've got no problem with that. My only the starting point of the conversation of 15.3, that 15.3 is based on paternalism, is what I'm wanting to challenge. It is true that the Constituent Assembly debates did talk about paternalism at that point of time. And should we still continue to talk about equality in terms of paternalism to women? That's all. Nothing more than that I'm saying. There's something for all of us to think about. And maybe we agree, maybe we disagree. But I certainly believe that we need to think about that, can there be a different way to look at 15.3? Whether 15.3 is coming only for paternalism towards women, or is it coming from difference of the women from the other human beings? So, okay, shall we look at the next case?
I agree with you.
Shall we look at the next case? What is the next case? Richa Mishra. What is Richa Mishra about? Has anyone of you looked at Richa Mishra?
Ma'am, we were discussing Richa Mishra.
Okay, the other one. No. Okay, so the Charu Khurana. Anyone who has looked at Charu Khurana? If you haven't, that's okay, but I've sent you the link, so have a look at this. We'll have a very quick discussion on this one. Charu Khurana was trained as a hairdresser, and she applied to be given a membership card from the association as a hairdresser. She was told to amend her application as women were not given the membership as hairdresser. No, she had applied for makeup artist. Sorry, she was trained as a makeup artist. She applied for membership as a makeup artist, but the association said, no, you have to apply for membership card as a hairdresser, and that's all we will allow you. Because makeup artist membership was given only to males, and it has never been given in the history of the association, which is the Cine Costume Makeup Artist and Hairdresser Association, to women. And the reason they gave, very interesting reasons they gave, they said if we allow women to become part of the, if they're given membership as makeup artists, men will not be hired by people because of the human tendencies, which will prefer women makeup artists than to men. And it will affect their livelihood, it will affect their families. And therefore, no woman has been and will not be given membership as a makeup artist. She can be given membership only as a hairdresser. And she should apply for that. So it was asked to delete the request for, she had asked for 2 cards actually. She was asked to delete her request for the makeup artist, was asked to apply only for the hairdresser. And so the second condition she cannot be given the membership was because she had not resided in Mumbai for 5 years. So there was a domicile requirement of 5 years, and none of her documents were proving that she was in Bombay for 5 years. So all your degrees, everything has been from Delhi, and merely because you had a bank account in Bombay for 9 years, banks can be operated from anywhere. So that's not a proof of your residence here. And when it was found that she was working as a makeup artist, a hefty fine was also imposed on her. She made a complaint to the federation, which recognized this association. And the federation permitted her to work as a makeup artist. And the association objected to the federation, saying that you cannot regulate this aspect. This is not within your jurisdiction. And please withdraw your license permission from Charu Khurana. And if she continues to work as a makeup artist, we will take disciplinary further action against her. So it is on these facts that the matter has come to the Supreme Court. So there are 2 grounds basically to look at. One, denial of membership, and the membership was important because without this membership, she could not have got any work. So this was a monopoly of that association in that sense, that unless the persons were registered as members with the association, the cine world will not give them any work. So now on these facts, so the one was this denial because she is a woman. I said this has been the history. It is not that we have taken her out. We have never given it to any women so far since our inception. And the second one is domicile. So what do you think? What should be should she be, is it violative of constitution? We know on the face of it, it is, but can there be a reasonable classification whether this argument of the association, and also remember that this association is a private association. So whether the violation of constitutional fundamental right to equality, no discrimination basis of sex, applies to this association. What do you think? We have to consider both whether the restriction on the ground of sex and on the ground of residence are justifiable, or whether they were discriminatory and therefore contrary to the constitution.
Ma'am, I read this case of Charu Khurana, and I did not agree with the Supreme Court decision because of several grounds. First of all, when I read this case, I found that Supreme Court entertained this case under Article 32 and saying it is a violation of Article 14, 15, and 21.
Listen, Rahul. First, we need to let everybody know what is it that the court has said, and then we will come to your objections. As it's an Article 32 petition. Yeah, what else?
The court gave the reasoning that because the trade union, the association was registered by a trade union, so by nature it is an act of state, so it is a fundamental rights violation, and therefore uh, the, it violates the fundamental rights, and the lady should get what she has applied for.
Mhm. But if
It
I can
cannot
make a
be
correction here,
denied to her.
the court did not say that. The court said that this association is registered by the Registrar of Trade Union under the Trade Unions
Yes,
Act.
ma'am.
The Trade Union Acts cannot be violating the Constitution, and it does not. When it lays down conditions for work, it does not put any kind of restrictions on the basis of sex. So when the association wanted registered, it is the duty of the registrar to ensure that the rules, the bylaws of the association are not violating the Constitution, which the registrar failed to do. They're not saying anything to the association because they can't do that. It says that ordinarily we should have asked the registrar to cancel their membership. So we are not doing that. We are only saying we are quashing those provisions which are violated. So which is the registrar should have done. The registrar should have struck down those provisions which were violating the fundamental rights. And because the registrar failed in his duty, and registrar certainly comes within the category because he has been given this power by the competent authority. So it is by that reasoning that the court has said these provisions are ultra violative the Constitution, violative of the equality principle, and no discrimination on the basis of sex can be permitted. I think we need to look at the reasoning of the court again. It is not directly saying that the association is a state. They're not saying anywhere that. They're only saying that the registrar of trade union is is authorized by the state, by the competent authority, and therefore comes within the definition of state. On the domicile, what did the court say? When you look at this one, they refer to lots of articles of the Constitution. And you know what I liked about the judgment? It's a very educative judgment. When you start from the beginning, the judge starts with referring to all the feminists from earlier times. So from Article 32 of the Constitution of India petition to referring to, look at this one. Look at on this one, para 2. Mary Wollstonecraft from her to subjugation of women by John Stuart Mill. So his kind of traces all the feminist writings to say that, look, we started in 1700 something and we still are facing lots of discrimination. Then the judge also looks at the international conventions as well, saying and refers to CEDAW as well. And what I found interesting is that they refer to Vishakha also in this judgment, saying that sexual harassment also happens, and they have also said that harassment has been caused to us as well. So, but at the end of the day, when he comes to the conclusion, he takes the reasoning which was presented by the argument. This was the first argument given by Meenakshi Arora on behalf of the Women Commission, saying that association is not a state, but registrar of trade union cannot be allowed to accept bylaws that are violative of constitution. This argument was accepted as the first reasoning by the court to say that why the provision which prohibited, and to say, and you know what I was finding very interesting, the in Nargesh Mirza's case, we have talked about the young and attractive women being necessary for controlling the unruly passengers. So we have historical images of women air hostesses in that case. Now here, again, this whole beauty thing has, in an indirect way, referred to and says the human nature is to prefer the women in such activities. And therefore, if you allow women in that field, it will take away the jobs of the men. And therefore, in order to protect men, we are prohibiting women, which is contrary to what the judge is saying in Richa Mishra's case. Richa Mishra, they said, we need to encourage women to work, etc., and they are not getting places. But here the association is saying that if you give places, if you allow women to become makeup artists, then women will take monopoly over the subject, and no employer would want to hire the male. So again, stereotypical images are being seen in this case, and the argument which has been given by the corporation. Now look at the corporation. It is very interesting to read when the federation asked them, when the complaint was made to the federation, the association replied. But they said that they had only, Charu Khurana had specifically made an application for hairdresser category, which wasn't correct because she was asked to delete her second request. Then he's saying it is a rule of association to disallow the female members to work as makeup artists. It is further to note here that Ms. Charu Khurana is also not an exception to the said rule that was introduced for the betterment of the association and not to discriminate on the basis of gender. Charu Khurana has been called for interview on this. She did not make herself available. Her application is still pending. It is clarified here that she is not a member of the association. Permission to Charu Khurana to work as makeup artist is illegal and now hereby, needless to say. Before this, I think there's another very interesting reply from the, yeah. This is what the association said. Complaint made by Charu Khurana is totally incorrect. She has desired to have two cards, makeup artist and hairdresser. She was duly informed that there was no system of issuing two cards simultaneously. On being appraised of the said position, she of her own deleted the words makeup artist in her application and countersigned the same and had agreed to apply and take her hairdresser's card. Insofar as the allegation of alleged discrimination and not issuing cards to female members as makeup artists are concerned, it is stated that makeup artist cards are issued only to male members from the date of formation of the association. No makeup artist card has been issued to female members till date. This is done to ensure that male members are not deprived of working as makeup artists. If the female members are given makeup artist card, then it will become impossible for the male members to get work as makeup artists, and they will lose their sources of livelihood and will be deprived of their earnings to support themselves and their families, because no one would be interested to engage the services of a male makeup artist if the female makeup artists are available. Looking to the human tendency, it would be appropriate to write to you that so far as hairdressers card are concerned, that is exclusively given to females and never issued to male members at all. There is absolutely no question of discrimination practiced by us, and everybody is given equal opportunity to earn their livelihood by exploiting their best talents. So see, this is what the association said in reply. And the judge said that, and so at one level, if you were to look at it, like, okay, there's a division of work. One kind of work is given only to hairdresser, only to women, and another kind of work is given only to males. So where's the discrimination? What do you think? Is anyone there?
Yes, ma'am. Ma'am, in with your explanation, the first question that comes to mind is what the association is a private body. So
Yeah.
how a private union is behaving like a sovereign licensing body? Because it cannot. And if we see and its clauses, especially the clause 4, it violates the Trade Union Act. So it should be declared unconstitutional, or its registration could be cancelled. Other than that, the submissions of the association itself is highly patriarchal in order. It is appropriating the role of woman, and it is laced with patriarchy and nothing else.
No, but the association is saying that we are not discriminating. You said hairdressers, women, makeup artists, men. What is the problem? So they have, both of them have got access to one kind of job. Where is the problem?
They cannot define what a woman should do and a man should do because it is unconstitutional. Like in the constitution, there's a freedom to profession, whatever they want. So
Mhm.
they cannot appropriate. Okay, because of a gender, you have to do this set of job, and because of this gender, you have to this set of job. That
So
itself, the
it
clause
is
4
discriminatory
violates the.
not only against women, it is also against men because
Also,
they are also not
yes,
being given a job.
yes, ma'am, yes, ma'am. They
So
are,
the
yes, ma'am,
restriction on
yes,
both
ma'am.
sides
It's
have
the
to go.
same, yes,
So
ma'am,
it
and
is
that's why it
uh-huh.
is violative.
So it is not only one. So when you look at these articles, so 39A is one set of directions there the judges referred to, and then said that when we are talking about adequate means of livelihood, very categorically it says men and women. You know what I noticed here was there are three words used in this article: citizens, men, and women. And I was thinking, are we including here the third? Because if this article did not use the word citizens, then one would have still said, oh, when the constitution did not recognize the third. But here it is saying citizens. And the TG community is certainly citizens. So I think in that sense, we can, in future, argument can be built up, even on Article 39A, to say that any deprivation of means of livelihood to the third TG category is inbuilt into Article 39A. When you look at here also the third point, health and strength of workers, men, women, and children are not abused. So workers, once you say that everybody has, citizens have the right to adequate means of livelihood, then it will again include the third also, the workers word here. Even we were to go by the biology of men and women, there is this gender neutral category called workers. And they are not citizens, are not forced to take up vocations unsuited to their age and strength due to economic necessity. So I certainly see the possibility of building up arguments by reference to 39A in future to include TG community into our discourse on working conditions, etc. And the second one thing the judge did say that many of the directive principles have become now part of the fundamental rights and therefore they have to be read together. And they said that through the third also, Article 4, the Chapter 4A, containing Article 51A, also has very categorically duty of every citizen to abide by Constitution, promote harmony and brotherhood, and abjure violence, is very categorically referring to inclusiveness and renounce practices derogatory to the dignity of women. Then it says 19(1)(g), right to profession, read with reasonable restrictions, and Article 21. When you look at all the whole scheme of the legislation, there is no scope for discriminating women on these grounds. So the court did allow this petition and says that the Trade Union Act makes no distinction between male and female members, and the discriminatory clause permissible, there's no discriminatory clauses permissible in the bylaws, which is registered under the Act. So the moment you are registering yourself under the Act, the obligation is on the registrar. And the restriction on basis of domicile, they said, is violative of Constitution Article 14, 15, and 21. And instead of deregistering the association, they said, we are quashing the provisions and we are asking, directing the registrar to call for amended bylaws from the association itself also. So in that sense, I believe that the judges were trying to have not tried, they have ensured that discriminatory, this is a series of more judgments have come after this. This was limited to the domicile issue in Maharashtra. And they had looked at a number of other judgments in which certain restrictions were made in admissions to medical colleges, etc., on the basis of domicile. And the judge have said, they've referred to the other judgment and saying that no such discrimination cannot be made. And here also they've said it is not permissible. So anybody who has an observation?
Ma'am, I have three observation in this.
Yes, please.
In this judgment, if
Hmm.
uh, the the court gave the idea that because the association is registered under Trade Union Act, and therefore Article 32 would apply, and it applied its writ jurisdiction. So then, if we refer to another judgment of the Supreme Court, that is Jaipur Shahar Hindu Vikas Samiti versus State of Rajasthan 2014, it said mere registration under the Act does not change the character of an organization from private to state. So
Yeah.
this, if we apply
No, no, no,
this,
no, no,
so
no, no,
how
no.
this
No, no, no. Who
automatically
are the, look at who are the respondents in this case? The association is only one of the respondents.
the association?
Federation, registrar, they all made the state government, they made everybody a party. These are only fifth. This is a respondent number 5. The association is a respondent number 5. The registrar is the federation is, I think, respondent number 6. So they have made state bodies also a party. Na? The direction is not against the association.
Uh,
The direction is against the
yes, ma'am.
registrar. And so they're not
Yes,
talking to the association.
ma'am, taking this further, this argument. So, if the association is answerable to the trade union and it owes explanation to the trade union and it's a party, shouldn't the person aggrieved or the matter itself first go to the registrar of trade union and then to High Court if needed? Because the registrar has the power of canceling the registration of the trade union itself.